Ready, start. All states continue to recognize at least a rebuttable presumption that a child born within marriage is the child of the husband, but continue to limit the circumstances in which it may be rebutted. Full stop. Several states grant the biological father a right to rebut the presumption and establish a relationship with the child. Full stop. Courts in other states apply the marital presumption based on a single inverted comma best interest single inverted comma clause analysis comma, that is, they will not allow the presumption to be rebutted unless it is in the child's interests. Full stop. These rulings often result in decisions upholding the marital presumption. Full stop. The courts in USA and England thus seem to maintain a strong bias towards the presumption of legitimacy. Full stop. Nonetheless, both jurisdictions have enacted specific provisions governing the procedure to order DNA tests when the legitimacy of a child comes under challenge. Full stop. However, this presumption is molded as the foundation for these provisions and cannot be displaced by mere allegations or suspicion. Full stop. The court can order a DNA test only after cogent and reliable evidence is laid to prove illegitimacy, and if the test is in the single inverted comma best interests single inverted comma clause of the child. Full stop. The courts generally refuse to order DNA testing when the child is born during a valid marriage between the parties, and especially when the applicant fails to prove a lack of sexual access between them. Full stop. However, if the parties undergo a DNA test voluntarily, the results of such a test can be admitted into evidence to determine paternity. Full stop. Here, we notice a consonance between the laws in all three jurisdictions. Full stop. While the courts have the authority to direct the parties to undergo a DNA test if a case for non-access is made out, the courts may also utilize the results of a voluntarily conducted DNA test to displace the presumption. Full stop. However, the standard of proof required in Malaysia seems to be higher than a mere balance of probabilities. Full stop. The above analysis makes it clear that courts around the globe have recognized the theoretical difference in paternity and legitimacy to the extent that in the Venn diagram of paternity and legitimacy, legitimacy is not an independent circle, but is entombed within paternity. Full stop. After adverting to the position of paternity and legitimacy in various foreign jurisdictions, it is imperative to evaluate the position in India in light of the unique factual matrix of the instant appeal. Full stop. The advent of scientific testing has made it much easier to prove that a child is not a particular person's offspring. Full stop. Indian courts have sanctioned the use of DNA testing, but sparingly. Full stop. Birth during marriage, conclusive proof of legitimacy. Full stop. The fact that any person was born during the continuance of a valid marriage between his mother and any man, or within 280 days after its dissolution, the mother remaining unmarried, shall be conclusive proof that he is the legitimate son of that man, unless it can be shown that the parties to the marriage had no access to each other at any time when he could have been begotten. Full stop.